my case is Gregg versus Georgia, which is about whether or not the death penalty is constitutional or unconstitutional, and does it violate the 8th and the 14th Amendments, yes or no. And it took a long way to get to where we are today with the death penalty, considering in the early 1970s it was declared unconstitutional, and through this case it was constitutional again. So the defendant is Troy Liam Gregg, who's convicted for armed robbery and murder of Fred Edward Simmons and Bob Durwood Moore. He was hitchhiking with them on November 21st, 1973, and decided to rob them. And he's the first condemned individual whose death sentence was upheld by the Supreme Court after the Furman v. Georgia trial. And on the night before he was to be executed, him and 3 other condemned murderers escaped by wearing homemade correctional officer uniforms and sawing through their cell bars and leaving in a car one of their aunts parked in the parking lot. And then later that night, he got into a bar fight in North Carolina in which he was beaten to death and found in a lake that morning. So, freedom isn't really all that sweet. And then the 3 other escapees were found 3 days later. It did not say where, but they were found. And the amendments that apply to this case are the 8th and the 14th. The 8th is allowing cruel and unusual punishments, and the 14th Amendment giving equal protection under the law to all U.S. citizens. So for the 8th Amendment, the courts ruled that if a proper procedure is set in place to condemn someone to the death penalty, then it is considered constitutional. And the penalty must also be proportional to the crime, meaning if someone killed someone, then they could be given the death sentence because they violated someone else's 8th Amendment. And for the 14th Amendment, it guarantees a due process of law. So if the trial was fair and legal, then his condemnation is also fair and legal. And there must be 2 trials that must take place. One to find out if he's guilty or not, and one to see if he's executable or not. And then capital punishment is defined as the legally authorized killing of someone as punishment for a crime. And it cannot be capricious or arbitrary, meaning that the ruling cannot be found invalid based on unreasonable grounds and without any proper circumstance. And then for the Furman v. Georgia trial in 1971 and 1972, they found that the process of the death penalty is unconstitutional because it did not guarantee everyone a fair trial. And then the states then changed their process to fit these new regulations that were given, and 4 years later, the first death sentence after this trial was declared constitutional, which is this trial. And an overview of what happened so far in this case is that he was found guilty of armed robbery and murder, sentenced to death, and then he appealed to the Supreme Court, and the death penalty was found legal through them, and which he was then condemned to be executed. So then in the Georgia's court, he received a guilty verdict from the jury on armed robbery and murder. In the second trial, he was sentenced to death, and then he appealed to the Supreme Court to try get him off death row. And then in the Supreme Court, it's important to note that he asked the court to rule the penalty itself and not the process unconstitutional. But that did not happen, and they said that he deserved his sentence because of his crimes. So the verdict for this case is 7-2 in favor of the states. And then they declared the penalty as constitutional and established a capital sentencing scheme in order to find the process to put someone in death row. So first on the capital sentencing scheme is that it must provide objective criteria to direct and limit the death sentencing discretion, meaning it cannot be subjective. And secondly, the scheme must allow the sentencer to take into account the character and record of the defendant, so all the details must be there for the judge or the jury. And these are 2 of the justices that served during his case. And up there is an abolitionist protest over his trial, and it's been 38 years since his ruling. And his case, along with 4 other cases, Profit v. Florida, Jurek v. Texas, Woodson v. North Carolina, and Roberts v. Louisiana, were all taken by the Supreme Court, and they were called the July 2 cases, in which all of them, the death penalty was found constitutional. And his impact was that even though he did not be executed, the ruling allowed for the death penalty to declare constitutional in other cases in the future. And there are many supporters and opposers of this, so it's a still ongoing battle. And today the death penalty is a very expensive process, and it's a very lengthy process to get someone to be executed. And there are 32 states where the death penalty is legal, including California. And that's like an execution room. And one of the justices, Potter Stewart, said that the death penalty is cruel and unusual in the same way that being struck by lightning is cruel and unusual. And then the next slide is just my citations.
Awesome
Thank
job,
you.
Quan.